Whoa,
on my
Hugo has a
forehead.
tie on today, sir. Look at that.
I mean, he is looking pretty fancy.
That is my formal wear. I keep it in my
He
pocket
put
for
on
cell
his
trials.
put on his formal poncho today. Look at that.
Oh no, this is
He's
the
got
same poncho.
Your prison themed one.
All right, Your Honor, we are ready.
Okay, let's start with Onyx. Please stand up. Okay, so the only charge we will be contesting is desecration of a corpse.
Correct, Your Honor.
All right. Miss Sinclair, please stand up. Okay, so we are going to be reviewing the one case count of capital murder and the one count of desecration of a corpse.
Correct, Your Honor. Your Honor, we are here today because my clients have found themselves accused of actions they did not commit. Do they admit that there was an incident that took place? Yes. Do they understand that these crimes carry weight behind them and that not only should they be respected, but those that do not respect them should face a punishment befitting that crime? Most definitely. We are not here to claim that my clients shouldn't face some penalty, nor that some of the charges brought against them do hold merit. However, in the process of investigations, the prosecution has most definitely skipped pivotal steps in the process of seeking the truth, with direct examples that can be drawn through the evidence brought forth today, as well as what we will hear in the testimony by the prosecution's witnesses, and possibly the defense's. Furthermore, here today, in front of this fine court, we are going to debate the definition of what constitutes a corpse, as according to the contradictory reports provided by the prosecution and testimony that we will hear here today, Miss Mia was not mutilated post-mortem, making one of the charges brought today to be wholly inaccurate. The proper methods of investigation were unfortunately at many junctures put aside in order to create a neat narrative that, while serving the purpose the state has created it for, does not directly coincide with the truth. I ask the courts to pay very close attention not only to what the prosecution provides, but what they will be selectively omitting, because here today we will prove that my clients are not guilty of capital murder, nor the desecration of a corpse. Thank you.
All right, we will begin. State, please call your first witness.
The state would actually like to, we don't have the officers here to testify, unfortunately, so the state would actually like to reference the report. Okay.
Which report are we referencing at the moment?
It would be report 254.
What's that one?
The disembowelment on Landak Dam.
Mm-hmm.
One of the longer ones that we read through yesterday.
Okay.
Yes. I would just like to draw attention to the first 4 images within that report.
The defense was not made aware of any images in accordance with that report, unfortunately.
Was the report not entered in full?
The information I was provided was via an email chain of an image, so I only have one document here with no pictures, all writing. I can provide it to the prosecution via an email if they would prefer.
Can you not access this?
I cannot.
On your MDT?
I cannot.
Here,
I made a formal notice.
I will give him access to it right now.
The state apologizes for the. It was the belief of myself personally that they had access to
Brady
the report
violation?
on the MDT. And I would ask that the state in the future fix the permissions on that, and just tell them not to go into stuff that they shouldn't be in.
Yes, I refrain from entering anything that I am not directly participating in. That being said, I did make a formal notice yesterday
that they didn't have these pictures, but they were entered properly on the docket. I would like to keep them in and give the defense time to review them.
Unfortunately, at this juncture, I believe it would constitute a Brady violation.
Well, they are on the case, and they were entered on the docket. So the report 254 was entered in full. Therefore, it was entered.
The Brady violation would also imply that they withheld it knowingly. I don't believe they did here in this
Respectfully, Your Honor, I believe intent does not play into a Brady violation.
It does not.
Well, Mr. Protesta, you should be able to read them right now. Can you check for me?
Certainly. Where would I be making this search? I see incidents, bolos, legislations.
Section.
Can you see reports?
I cannot see reports.
Try it now.
Now I can see reports.
Can you see those 4 pictures now?
Yes, however, I currently see 15 pictures, Your Honor. I am pouring through all of them. I am doing my best here right now to give the prosecution some leeway considering the situation they find themselves in, but the level of information here right now has me quite concerned about a Brady violation. As this information, I did document yesterday that I was having significant issues seeing that, and the PD did willingly offer me the information and say that that information was in full, and at this juncture, I find out that it is not. This significantly hampers my defendant's ability to actually, carry this court case through and defend themselves based on information being applied at 45 minutes post-original trial start.
Okay, well, I will hold my decision on that for now, and I will rule on that later. Was there anything else that you want? Huh?
I find myself not inherently disagreeing with the defendant in this case sometime, and I would at least request that he's given 10 minutes or 15 minutes to review the information that he has just been handed and once again apologize. It was not the intention in any way, shape, or form. The belief was that the MDT was open access to you at this point in time, and I apologize.
I understand and appreciate the apology.
Would you like a recess to review the evidence?
Can I ask whether I take the recess or not if this information will be entered in formally into the case?
I'm willing to go back to chambers if we want to discuss it more privately.
Yeah, we could do that if you want.
I'm going to push on this hard for you, too, because if we can get all this dropped, it's going to make them much harder time.
20 minutes later.
All right, so one of the pictures helps us, so I have them keep it in, and some of them are being pushed out. Not all of them, though.
Did a lot of research on what constitutes a Brady violation, and there are a lot of factors as to what constitutes Brady violations. Therefore, there are a few items that will be tossed. That will be a witness testimony from Boville. That will be a text message, as well as one other report that is covered. Other than that, everything else is in.
Your Honor, one other detail there, the knives at the end. We also agreed that the knives would be dropped, yes.
And aluminum.
Can you describe the dispatch call that led you to the Land Act Dam that day?
I can, yes. So I was patrolling with, at that time it was probationary trooper.
Objection.
I believe.
Witness is entering into a narrative. Objection,
yes.
Leading.
Overruled.
What did you observe upon arriving at the scene?
There was a body chained to the ground. It had been cut open, and what looked like organs had been removed. On the body, the little and the ring fingers on the right hand had also been removed. When I got closer to the body, I saw words had been what seemed to be carved into the body.
What words were carved into her?
If I can remember right, I could be wrong, but it was R-O and A-F.
Prosecution would like to note that those are the initials of the two defendants.
So, you said you found a body. Did you check for signs of life?
I specifically didn't.
Do you know if any other individuals, as part of your force, attempted to render emergency aid to this individual?
As the San Andreas State Police, with our medical aid, we have to check signs of life. I specifically didn't, because I was scene lead.
So you arrived first, and you didn't check for signs of life, and to confirm here, nobody else, as far as you know, checked for signs of life.
An officer did, I just can't remember who it was.
Alright, so, next question here. You didn't render emergency aid, and you're unsure of who checked the body to see if they were even alive or not. Did it not occur to you at any point that they may need aid, that they may still be alive?
Objection, speculation.
I'm asking whether it ever occurred to the individual. It's a yes or no question as to whether it happened to him in the moment. I'm not asking as to whether he is ever I'm not asking him
You
to
asked it,
speculate.
did it ever occur? You're asking to speculate in the moment.
I'm asking if that ever happened to him. I'm asking if that specifically happened at any juncture when he was there. Did he think that he should render emergency aid? I'm not asking him to speculate on what would have happened. I'm not asking him to speculate about what he would have done. I'm asking him if that happened to him in that moment.
Could you please rephrase the question?
I'll actually withdraw the objection. I think it's fair.
Can you ask the question again?
Did it ever occur to you at any point that that person may still be alive?
We do try and we do check, yes.
It's
So
a yes or no question, sir.
Yes.
Okay, so it occurred to you, but you didn't bother to render emergency aid or check. All right.
Was the person visibly dead?
Say that they were
Objection.
dead on.
Opinion of a layperson. They have stated openly
Oh.
that this individual is not an expert in the medical field.
Thanks, man. Good point, Hugo. Okay. Nope. Anything else, Rose?
Did you perform an autopsy on May 8th of this year?
On May 8th?
She's trying to remember.
I'm going to withdraw and rephrase. Did you perform the autopsy on Miss Mia Mercetti?
Yes.
What day did you perform that?
May 2nd.
How did you identify specific injuries were inflicted post-mortem?
By the lack of the pooling of the blood.
If one is bleeding out and losing blood, would they not bleed less from injuries?
Correct.
So you used pooling of the blood to identify time of death, but you also state that pooling of the blood can be subjective based on how much damage is done to one person.
Objective. He's also testifying. Can he ask a question instead of trying
No,
to...
I'm
put words
asking
in
a specific question there. She's saying that she pooled it on the blood. She's saying that she identified time of death based on pooling of blood as well as the
You're
postmortem.
asking her to re-say something.
okay.
You're saying, are you saying this?
Let's stop for a second, Mr. Patessa. She actually stated she determined cause of death or time of death based on body temperature. That was asked and answered, and then you asked if how she knew those wounds were post-mortem, and she said that was determined due to blood pooling. So the blood pooling had nothing to do with time of death.
However, exsanguination would directly determine blood pooling, would it not, Your Honor? As she openly stated after that as well, the fact that a person is bleeding can lead to them bleeding less from certain injuries. They have less blood in their body to bleed and less pressure, less blood pressure.
Can you ask her a specific question about the blood pooling?
He's stroking.
Well, the officer's crank, I stroke. Apologies, Your Honor.
Hey, everybody loves a good crank and stroke.
I move to have that officially put on the court record, Your Honor.
Yep, I said it. It is on the court record.
It is on the court record.
So what was the manner of death for this individual?
I mean, it is possible. For
Objection, asked and answered. Is exsanguination.
What was Miss Sinclair's legal status as of April 3rd, 2025?
Objection, relevance?
Sorry, my brain short-circuited. That wasn't meant to. Can you describe the nature of the crimes that she was convicted of for the court?
Objection? Counsel is requesting a narrative.
What was the nature of the injury sustained from torture?
Objection, relevance?
We are trying to establish a pattern, Your Honor, of repeated violence and torture against victims.
You said Rebecca was murdered. Do you know the motive for this murder?
Rebecca had slept with Amelia's ex-girlfriend, Amber, when they were still dating.
In your experience as a special agent, would that be defined as a crime of passion?
Objection, relevance?
Well, in the opening of the prosecution, they specifically stated that these killings were not crimes of passion, so I believe that this directly refutes the prosecution's stance.
It's not relevant to the scope of our questioning at all.
Well, then the objection would be scope, not relevance.
I'll allow the question to be yes.
Can you repeat the question?
I asked if, in your experience as a special agent, if that type of crime would be considered a crime of passion.
Yes.
All right, moving on to the second victim then. Did Amber have any relation to my client?
Yes, she would have.
And do you know the motive for Amber being murdered? Actually, apologies. I'm going to ask a question before that. What was that relationship?
She was her ex-girlfriend.
Okay, and the motive for the murder then?
She had cheated on her with Rebecca.
Okay, so another crime of passion then. So, last question. Do you know if any of the damage inflicted on these victims was inflicted post-mortem?
On those ones, none of it was post-mortem.
Fantastic. Thank you very much for your time, Special Agent. No further questions from the defense, Your Honor.
Prosecution, do you have any redirects?
See, that did a lot of heavy lifting for us. That did a lot of lifting.
I'm just surprised they're not asking me anything in relation to me.
Well, they're going to try and get you with the desecration, but realistically, they're going to have a real hard time with that. And that's why we're going to have you go up and just say, nope, the last thing we did was pull her heart out.
All of the questions are relating to Amelia.
They're trying to push the
it is
capital
the first
murder.
degree. Okay, yeah. Capital, that makes sense.
Yep. Getting shredded.
Did you have any redirects, prosecution?
Can you not hear me? Am I?
No, now I can hear you.
Okay. Sorry. Yes. What were the charges that Miss Sinclair was being apprehended for by the FIB?
Objection, relevance, and best evidence.
Your witness, Mr. Testa.
Thank you, Your Honor. I'm going to keep this very concise and clear for the courts. Hello, Miss Onyx. Very simply put, did you harm Miss Mia?
I did.
Why did you harm Miss Mia?
Because her and her brother harmed me years ago.
What was the last thing you did to Miss Mia?
Objection. Can we get a little it's narrative? It's an open-ended question.
I do believe that the question should be less than a sentence long. In answer, it will not provide a true narrative. If you would like me to rephrase, I can. However, I believe the answer will be quite short.
If you can, I will still hold my objection.
Yeah, could you rephrase it a little bit?
What was the last act you took when harming Miss Mia?
Last act I took
Yes.
was slicing her throat.
And was she still alive after that?
I don't know. I believe so, due to the fact that her heart was still beating.
Objection. Withdrawn.
Alright, so her heart was still beating. After this next slice, did you cut off any fingers?
Before, not after.
Thank you very much. Just for clarity, I would like to highlight the testimony that has just been made here. My client states that she did in fact remove Miss Mia's fingers, but it was not post-mortem, as the individual had their heart still beating after the last act taken upon them.
I'd like to motion, I guess, call for perjury, Your Honor. The testimony we just heard today was completely opposite of everything found in the medical report. And therefore, impossible in nature. Therefore, she is lying.
Or the medical report is incorrect. There's
no proof presented today that the medical report was incorrect.
Actually, I believe through my questioning, I have cast significant doubt on the medical practitioner's report, and can continue to do so. That being said, I believe that's at the judge's discretion.
Yep, I'm still bringing it up.
I will consider the perjury charge while I consider my ruling.
That's the narrative my client
Do you
provided
have
to
any
me.
questions for the witness?
Was your co-defendant on scene at this?
Objection, scope. None of my questions mentioned the co-defendant. None of my questions implied the co-defendant. This is outside of the scope of questioning.
Withdrawn, Your Honor. Sorry, I was teaching a lesson to my co-counsel. Why did you remove the fingers?
Objection, asked and answered. Motive has already been described.
I asked for the motive.
I'm gonna overrule. Why? You can ask specifically why she removed those.
Why did you remove those fingers?
Because those fingers were the ones that she removed from my sister.
Did you have any help removing the fingers?
Objection, scope.
Within the scope of the last question, Your Honor.
Overruled.
Damn it.
No.
Okay, Mr. Potesta.
Thank you, Your Honor. I also do wish to compliment the prosecution. I think they have a great future in public speaking. Your Honor, as I have proven today, my clients, while definitely in need of some reform, did not desecrate Miss Mia's corpse, nor was she even a corpse when my clients last saw her. Furthermore, the capital murder charge being brought against my clients does not meet the necessary burden to be brought against my clients. The prosecution has not proven the intent behind these murders besides a crime of passion, as the phrasing of the law specifically states that one of the three prongs must be met. The prosecution has not proven that the only person who died, Miss Mia, was a witness and was being silenced, a government employee, nor was this a component of a string of random nor motiveless killings that would constitute serial killing. This was a personal vendetta and a crime of passion, regardless of how the prosecution frames it, that was carried out against one individual, albeit quite brutally, but brutality does not change the nature of the charges in this instance. It is not one of the prongs. The special agent that came up today attested that my clients have no record of desecrating a corpse before, and that there were clear motives in all of the killings attested to or brought up today. Killings my client has already been charged for in most instances. The prosecution has provided broken and disconnected documentation and evidence, including a medical report that my clients directly dispute as being inaccurate, and through questioning, I have demonstrated many ways this mistake could have happened. Her heart was still beating when they finished. We heard that today. And the police department did not take due care in attempting to save this person after the incident. If emergency aid had been rendered, a life might have been saved. For something of this severity, only the highest standards should be tolerated when bringing charges this life-altering. This is not a parking ticket. This will completely upend my client's future and should be dealt with in the most meticulous and professional way possible. Unfortunately, there were many points where in this case, this level of care was not upheld. Considering the case the defense has made today, I request you find my clients not guilty on all contested charges. Thank you.
Okay, first off, Onyx, I understand, and the court acknowledges that you wish to be called Onyx, and anytime I'm talking directly to you, I am calling you Onyx. However, when I read out my ruling, I do have to state you by your legal name for the court record. Alright, that is not an address to you, that is an address for the court record. Because if I do not put your full legal name on there, it would not be legally binding. Understood?
Understood.
Okay, today I'm going to start by addressing my ruling regarding Miss Stevens' testimony and the motion to strike the testimony. I find her testimony to be relevant, and it highlights an ongoing campaign by the defendants to seek revenge against those that they believed has wronged them. Then the nature of these injuries clearly connects the murders to one another. Therefore, I will allow her testimony.
Damn it.
In regards to the prosecution's claim that Miss Onyx committed perjury, it is an important note that perjury requires deliberate intention to lie. This court finds that the defendant is not in a position to accurately determine the exact time of death. Therefore, Miss Onyx will not face perjury charges concerning the facts of the case, considering the fact that based on the medical reports and the testimony in here, The acts all happened in rapid succession, and the acts that did, in fact, technically occur after the defendant died happened in the act of the murder of itself. Concerning the facts of the case, I find Miss Sinclair guilty on the one count of capital murder. However, the court concludes that all injuries inflicted during the torture and the execution of the victim happened in rapid succession, meaning that these injuries were part of the act of the murder rather than the desecration of the corpse afterwards. Consequently, the court finds both Miss Sinclair and Miss Onyx not guilty of desecration of a corpse.
Good.
Oh.
How does that feel?
That
So,
feels good.
All right. Case dismissed.
Boom.
Thank you, everyone.
Closed.
I'm glad to have not gotten shot at in this court case.
Yeah, I just feel like there was a slight misunderstanding between the local coroner and the medical examiner.
Which
Most
is not on the
likely.
medical examiner at all. She seems pretty chill.
Yeah, that's why I
Yeah.
highlighted possible mistakes instead of saying it was negligence. That's also why I didn't want to give her the 12th degree. I already kind of dialed it up to 11 and called that good enough because I don't need that. She
12th
already doesn't
degree?
like me. Yeah, you ever heard it turn up the dial to 11?
Let's get these ladies on move on.
I guess.
It's from
Yeah.
Spinal Tap. It's a movie about musicians.